we are talking about Indigenous people and Saskatchewan's criminal justice system. We know there's a gross overrepresentation here. On any given day, if you look at Saskatchewan's prison population, 75 to 80% of the people in there are Indigenous. Just let that sink in for a moment. Up to 80% of the people in prisons in our province are Indigenous. I think it's easy to see why this system is failing Indigenous peoples. And for years, we've heard for advocates saying we need an overhaul. There have been calls to replace what we're working with right now with a new system, one founded more on healing, on restorative justice, one that would slow down or possibly even stop, in some cases, this whole revolving door of criminal charges and incarceration. Well, today here on Blue Sky, we're speaking with three people who've worked extensively in the criminal justice system. They each bring a unique perspective, and we're hoping we can have a thoughtful conversation on possibilities for Saskatchewan. Maybe we can re-envision what an Indigenous justice system here would look like going forward. Well, our first guest today is Krysia Przepiorka. She's an Indigenous defense lawyer with the Calgary Indigenous Court. She's also a member of the Carry the Kettle Nakoda Nation, and she joins us from our Regina studio. Hello there, Krysia.
Hi, good afternoon.
And we'll move to our next guest, Gerald Morin, who grew up in Cumberland House. He's a member of the Peter Ballantyne Cree Nation. And between 2001 and 2019, Gerald Morin served as a Saskatchewan Provincial Court judge. And he used that time to pave the way for a Cree-speaking circuit court that travels across northern Saskatchewan. Gerald Morin is now retired, and he's living in Prince Albert. That's where we've reached him today. Hello there, Gerald.
Good afternoon.
Thank you for joining us.
Yes.
And here in our Saskatoon studio, we have Andrea Phillips. Now, she's Métis. She's the Indigenous Policy Council with Legal Aid Saskatchewan. Hello, Andrea, and welcome to Blue Sky.
Hello, good afternoon.
And all of us, I'd like to welcome all three of you to the show, and we'd also like to welcome our listeners. And the question we have for listeners today, as you're sitting and listening to what our callers and our guests have to say, does Saskatchewan need its own Indigenous court? And if the whole idea is that we'd like to start incarcerating fewer Indigenous people, well, where does our existing justice system need to change? If you have experience with the system, or if this brings a few thoughts to mind for you, please give us a call at 1-800-716-2221. As always, our email is bluesky@cbc.ca. So I think maybe before we start jumping ahead to solutions, we should just sort of do a state of how do things look right now? Why is it that Indigenous people are so overrepresented in Canada's criminal justice system? And Gerald, Krysia, Andrea, you're welcome to jump in wherever you like, but I'm going to throw this one, I think, first to Andrea and then to Krysia. And please join in as you see fit.
That's a huge question. But it's a very important one. And I think that fundamentally it comes down to a misunderstanding of the colonial history and the impacts that colonialism has had on Indigenous peoples. A lot of people, I've heard people say, well, that's over. We're not doing it anymore. Get over it. Those types of comments, which just show the ignorance toward what has actually happened and what is continuing to happen. There was a lot of harm done, a lot of trauma experienced, and I used to use the term intergenerational trauma, it being passed down from one family to the next, because we live what we learn. And if a family has lived with their entire lives large amounts of trauma, that gets passed down. But I recently spoke with a very insightful woman from Pasqua First Nation who had suggested that we're coming into a time where intergenerational trauma should perhaps be referenced as generational healing. And that took me aback, and it shifted my perspective a little bit. And I think that we are entering a time where generational healing is the road forward.
Okay. All right. And that's Andrea, who's joining us here in our Saskatoon studio. Andrea Phillips is Indigenous Policy Council with Legal Aid Saskatchewan. Okay, over to you, Krysia. What I guess, why do we have so many people, even here in Saskatchewan, why are there so many Indigenous people in our jails?
I think Andrea really hit the nail on the head with that statement about generational healing versus intergenerational trauma. And, we as society, I think, have to understand the depths of the wounds that we're dealing with. And understand that those don't heal overnight, and they take a lot of support and a real restorative, structured system to start sort of undoing the damage that has been done to our people. And so that statement is so true. We're moving into a phase of healing now, and that's, especially when we look at our justice system, that's the level that we're dealing with now, in my experience, is something that we've not had before. And I've been doing this for just shy of 14 years, but the direction that we're moving, at least in Calgary right now, is very therapeutic and restorative. And I think that's really where we need to put our energy right now, so that we can start reducing the numbers that we're seeing. I mean, it's not just males, it's females are increasing, it's youth that are detained in centers. So it's now is the time that we have to make these changes, because what we've been doing in the past has not been working.
Well, and Gerald Morin is also on the line with us from Prince Albert. He's been a retired provincial court judge for a few years now. And Gerald, I know you've got a unique perspective to sort of be able to speak frankly. It can be a little tougher when you're a sitting judge. What do you see as some of the problems with the current justice system in Saskatchewan, the problems that are causing harm to Indigenous people?
I'm not so sure people would say that I was sorry about what I was talking about in the past, but I know in my experience, I was first a probation officer. It's going to age me a bit, but in 1973. I worked in different capacities onwards, becoming a lawyer back in the 80s, practicing until 2001, and into judgeship. So I didn't come into it blindly. I didn't come into it thinking that I was going to make a great deal of difference. But certainly, I think it is a big question. It is a big, major thing to say with the numbers that you cited. There are many factors. Poverty is a major factor. Marginalization is a major factor. Then you start looking at some of the responses in relation to the system, and then you see the ratio of police versus the number of people. If you put the number of policemen into different northern communities, what they have as a ratio, we have greater numbers of policemen in northern situations. Of course, the negative contact will be greater, and you will have more people being in contact with the police than you do in city situations. If you start looking at how they're looking at dealing with situations in the city, you will see things like gang unit. You will see response units. Again, it's a concentration of police efforts to a smaller community within the larger community. Again, it's in response to poverty situations. Those are things that have been consistent. So the nature of the relationship of enforcement, the nature of relationship of meaningful participation within the wage earning economy, and how we are so quick to criminalize many, and then we effectually have them to be non-participants, because who hires people who have criminal records? We're very quick in building criminal records. Those are the practical things that I've seen over the years.
Well, and those are things that directly affect people's lives. And I know in the United States we talk about the school to prison pipeline, but in communities where you're talking about over-policing or like all this enforcement and being quick to criminalize someone and sort of label them with this criminal record, what future do they have after they're 18 years old and you have a criminal record following you around?
That's exactly.
I know that one thing that And we're kind of looking at a better future. I got to remind our callers and our listeners, we are looking at what would it take to build a better future for Saskatchewan's courts and to bring some of the concepts of restorative justice in and to just make them a bit more even-handed as far as it comes to Indigenous people. One thing that's come up, we did a big piece on this here at CBC last year, GladU Reports, something that the Supreme Court has said that every Indigenous person who is before a court has a right to a GladU report. I'd like to ask you three about what they are and how they're used in Saskatchewan. And when I come back to you, Gerald, how did they affect the way you might have had to sentence someone? So, Andrea, if I'm going to start with you, just in brief for our listeners, what are GladU reports and how does Saskatchewan use them?
A GladU report is a report written about an individual offender that takes into account their unique history and systemic background factors that may have resulted in them being before the court in a criminal matter. It takes into account not just those individual circumstances, but also the circumstances of the community in which they came from. Because as was mentioned earlier, not just by myself, but Krysia and Gerald, there are traumatic events, and it may not necessarily have happened to that person specifically, but they may still be feeling the effects of them. And then it takes into account positive things that these people that we call offenders have done in their life, whether that be attending rehab and getting sober or upgrading their education or participating in different types of programming that would lead them to find career opportunities. Because again, as Gerald had mentioned, positive participation in the economy and in society and within community is huge. And if we don't provide opportunities for everyone, it's very difficult for people to make positive steps forward. And then with respect to Indigenous people, we really want to focus on how can we make certain that, this is rehabilitative, that this is a tool used to help heal that individual while making certain that reparations are essentially paid toward the victim in the community for the harm that had been done by whatever offense it was that was committed.
And the whole idea is to give this report to a judge before sentencing.
Yes, absolutely.
So this isn't something that a jury would necessarily look at. This is more after that.
That's right.
Okay. One of the things that I remember coming up in some of CBC's reporting on this last year is that the Ministry of Justice in our province showed that they had paid about $78,000 or so to pay for 24 GladU reports. But those reports stretched from 2016 to 2021. There were only 24 of them. There were independent agencies, there were private dollars that paid for others. But if every Indigenous person has the right to a GladU report, what happens in Saskatchewan? How often do people get them?
I have been on a mission for the past couple of months to determine the number of reports that have been written in Saskatchewan for the last year. So sort of the March 31st, 2022, coming up to March 31st, 2023. And the answer is I don't know. I know that court-ordered reports are few and far between at this point in time. I know that there are some private writers that are writing anywhere from 1 to 12 per year. The estimated number that I have at this point within that fiscal year is about 40. So people are told that they can have a pre-sentence report that includes GladU content, or they can pay for their own report, which will range in price.
So the province, the courts don't guarantee that you'll have a GladU report written if you're an Indigenous offender. Not in Saskatchewan?
No, they do not.
Krysia, how do things work in Calgary?
I've had the experience of, on one occasion in Regina, where a client requested a GladU report and the judge said, yeah, your client can pay for it. And I was gobsmacked. In Alberta, particularly Calgary and surrounding areas, that's where my focus of my practice is, we order a GladU report, and I do for almost every single Indigenous client I have. And those are court ordered. My client does not pay the cost of that report. And those reports are extremely private and detail not only sometimes my client's trauma, but the family's trauma. And so when I'm concluding a sentencing, I am reluctant to have them marked as an exhibit on the court file, or sometimes our courts will seal them because of the private traumatic content of some of these reports.
Okay. So it sounds like in Saskatchewan right now, it's pretty much the onus is on the person who would like to provide the judge with a GladU report to pretty much go and pay for it themselves or find a sponsor who'll pay for it for you. And I look at it, and Gerald, up in Prince Albert, when you were a provincial court judge, how did these reports change or affect the way you would sentence someone?
Well, I think the answer's already been given. Have I ever seen one is probably the question. Have I ever ordered one? Have I ever had one produced? No, never.
Not once?
Not once. Has
Why?
ever been requested in terms, I think there have been one or two requests, but nothing, there was nothing on stream, so you're left to look at what other things you look from GladU. I think I can say I'm lucky and unlucky. My father went through residential school. I have family that have gone through residential school, not immediate, but extended family. So I know lots of people that have gone through that. I've seen certain effects within my family based on the type of residential school they went. What I looked at in looking at Truth and Reconciliation was to understand in the number of residential schools we had. So in my area, I wanted to know which ones affected the people that come before me. So I look at places like Prince Albert. I looked at Guy Hill. That's where my father went, Sturgeon Landing, back in the 40s. And then they moved it to the Paw. I looked at all that history to understand what it was. In other words, what was Sturgeon Landing known for? It was known to be more labor intensive. Okay? They had a sawmill. They grew a garden. They had cattle. So they learned all those things. Reading and writing, yes, it was there too, but minimally. Was it brutal in certain aspects? Yes, it was. Then I would learn about Prince Albert in the past. It was the one that was most detailed in relation to being one student-to-student violence. Those type of things, I went and learned about it.
But you took that upon yourself. But
yes,
I also wonder...
in the GladU decision, the court talks about judicial notice. Well, judicial notice, in my opinion, is just not to ramble about things, but learn about it and see what it is and how it applies to different communities you worked on. I emphasize that to my colleagues. Whether they listened or not, some may have. But that's certainly something I talked about within our meetings, within those type of things. And it's the resources. I complained about resources in terms of what was needed. It's one thing to have judicial notice. It's another thing to say, what are the resources that we have in order to get this information? Mm-hmm. There was none.
So if you give someone no resources, and for all the other provincial court judges who are working at the same time as you, I don't think I saw as many of them going to the same pains and lengths in every case. That's a huge gap.
It is a huge gap. My understanding, like I said, comes from the fact that I grew up with it, seeing it in front of my eyes, So those type of things and understanding that. It wasn't until 6 months before my father died that he disclosed certain things to us as adults. My father died in 2014. I remember taking him to see his own brother to try and reconcile a difference they had about where their understanding was. Because one of the brothers said that he was raised by white people. In other words, he denounced his own family and his own parents because that's what he was taught. So you know the impact of that type of thing, but I remember that discussion. I remember that discussion very clearly. They did not reconcile their differences to the day they both died.
Oh,
that's a sad situation.
Indeed.
So do I have a deep understanding of it? Yes, I have a deep understanding of it. So it didn't just look at trauma in that sense, but this is trauma in a different way of thinking that you were raised by some other group and denounced your own parents. That's devastating. I remember looking at it. I was an adult. I was a judge when I was listening to that. Those are the type of things that not only did I take judicial notice, I experienced it. So to look at it and say, how could those reports have made a difference? I believe they would make a major difference because our sense of judicial notice is just to say, maybe here lawyers set out, he attended the residential school and he had major things happen, but they don't understand or do not articulate clearly what type of trauma as being dealt with it, on what occasions, what type of things still bother him, what triggers him. Those are the type of understandings that one needs to know. So if a person is being charged, for instance, with assaulting a police officer, what was triggered in that confrontation? Was it triggered because the last time, a lot of times he dealt with police in the past was when he was picked up or when he was confronted in different situations? You know, those are the two things that one doesn't understand fully until you understand intrinsically what that person experienced.
And this is, yeah,
it's pretty major.
It is. It's huge. And as we talk about envisioning a better future where we try to incarcerate fewer Indigenous people in Saskatchewan, you're listening to Gerald Morin, who's now a retired judge living in Prince Albert. He's a member of the Peter Ballantyne Cree Nation. I'm Jennifer Quesnel, and I'm sitting in today for Garth Materi here on Blue Sky. And yes, we are talking about courts here in Saskatchewan. What could we do to just incarcerate fewer Indigenous people and to stop or at least slow down the revolving door of criminal charges that seem to come for so many people? Now, one of our guests today is Krysia Przepiorka. She's an Indigenous defense lawyer, and she's based out of Calgary, although she's a member of the Kettle Nakoda Nation, just east of Regina. And one of my questions for you, Krysia, is in Calgary, the Calgary Indigenous Court was established about 3 years ago now, still fairly new. Can you explain in a thumbnail how it works and how it's different from a regular court?
Absolutely. So we have a phenomenal case management table that encompasses a number of entities within the city. It's led by Elizabeth Fry Calgary. We have a phenomenal team. So we do a referral. They then get paired with a case monitor through eFry. And then throughout the course of their meetings, their needs are sort of assessed in terms of if the client has, say, for example, addictions issues. Before they go down the path of their healing plan, it may be recommended that they engage in residential treatment or day programs that are offered. We're very fortunate in Calgary. We have partnerships with some residential treatment facilities as well, detox, and we're working on pre-treatment bed partnerships as well. And the idea is to use healing, and the healing plan is the crux of the Calgary Indigenous Court. So you meet with your case monitor, you meet with your elder. Sometimes there's psychologists or psychiatrists that are involved, and they create a healing plan to sort of delve into the root causes that have the individual before the court. And we're very cautious in Indigenous court. I don't, and I make a point of not calling them accused. They're participants. This is their process. This is their healing journey. They're the ones that are doing the hard work. So they are participating in this court process. And so just to be really respectful of what we're trying to achieve in that courtroom, we're very selective of our terms at times. And it's really using a restorative therapeutic approach. And once you complete your healing plan, you then ultimately get put on a list for a blanket ceremony. And as you work your way through your healing plan, the Crown has discretion in that courtroom of how to deal with your matters. The idea is to not compound these criminal records that have been developed over the past, sometimes multiple decades with the participants. And so we're really looking at overall breaking down these barriers that have been created over the years with our justice system and taking a whole new approach in dealing with our participants. And that comes all the way down to sentencing. But it's not a get out of jail free card. This program, it's hard. It's a lot of work for the participants because they're the ones that have to do the work. They're the ones that have to complete their healing plan.
Well, and this brings up a lot of questions for me, but I'll also let Gerald and Andrea sort of step in here. Do you see a model like this working in Saskatchewan? And also, I'm guessing that, Krysia, is this for every Indigenous person who comes across court or just some? Like, does this work when it's a murder charge or a very serious charge?
So by virtue, murder is dealt in the higher jurisdictions, but we, in Calgary Indigenous Court, we do have a manslaughter file in there right now. I've brought that file in, and the participant is doing very well. So it as long as you identify as Indigenous and you're prepared to put the legwork in, you're eligible to participate in Indigenous court.
Andrea, I mean, from your work with Legal Aid Saskatchewan, do you see elements of that could work here, or does it need to be sort of its whole own separate system?
I definitely think that I think it needs to be its own separate system, and I think what Krysia has just described would be very beneficial in Saskatchewan. I know that there are a lot of nations in our province that are working toward self-governing and creating their own justice systems. But this, I think, could be a very effective sort of stopgap, something to assist until each and every nation does have their own form of a justice system. Krysia had mentioned a lot of community supports. And I think that is something that is critical in order for a system such as this one to be successful. We really need to reach out and start building relationship with the Indigenous community-based organizations, as well as the services that they have to offer and the nations themselves in order to see this type of system be effective. And I don't know if we have time, but perhaps I'll reach out to Krysia after just to hear about the process in having this type of court implemented.
Well, and it brings back for me who I used to report on courts, and I'm thinking about you, Gerald, up in Prince Albert. One of the things that you managed to do is you brought the Cree-speaking Northern Court Circuit into Saskatchewan. And this is where there were, the court would just travel from community to community, and proceedings would all be held in Cree. It's still Saskatchewan courts, but looking at that, it was still what some people might call the colonial courts model. But looking back on it now, what do you make of it? Like, what difference did it make for people who could at least have the proceedings in what was often their first language?
Well, I think different people have said, smarter than me, have said, if you talk to a person in a language they understand, you reach their mind. If you talk to a person in their own language, you reach their heart. I think because our language is not only a language, but part of our culture in relation to our understanding of our predicaments. The Cree court, in doing what we did, was that we dealt with each and every case. I started counting in terms of major in one community in 2005, and I dealt with about 16 murders. In terms of prelims, late night prelims, of course, they went into Queen's Bench. I dealt with numerous sexual assaults, dealt with numerous domestic violence issues, but we did not have the resources in relation to dealing with those in terms of a very specialized process, for instance, in domestic violence. We had to react to what was called zero tolerance by prosecution unit, who said once they laid the charge, because there are different pressures they have to respond to. Number one is they don't want to drop charges that easily. They don't want to do things in a different way. So they would dogmatically, in a dogmatic manner, stick with the charge, but knowing full well chances of somebody appearing in court to testify was nil. So often you'd say, Crown, call your case. With that approach, they call their case and you say, you got no case. Nobody's here. So what did zero tolerance get? A dogmatic approach to which they might feel good they're trying something, but they didn't accomplish a darn thing.
Well, and
They'll
this
put it in a situation where a person was still not having the resources, both the perpetrator and the victim. So those type of things really missed. We didn't have the resources. Perhaps now they could look at it in certain ways of saying, you have video, can we have the psychologists and all the resources that Calgary might have? We don't have in small northern communities. They don't like traveling to those places, So those type of things were missing. And the reality is we don't have those resources at all. Perhaps now with video you can in a lot of situations. Those type of things are ones that communities wanted desperately. What was their avenue of dealing with that? Well, you got a criminal justice system, and the services handled by the criminal justice system is the province. When the province has a problem in dealing with First Nations people in terms of an equalized process and to even access wealth in the natural resources world because they don't feel they have any obligation to Indigenous people, where do you think it comes down to in priority? The priority comes down in relation to making sure that you have enough resources with respect to making sure there's jails, making sure there's those type of things. But what type of self-help situations do they have, and how much are they willing to spend to that community? That's part of the issue.
It is. And you know what? You've got the phone lines lighting up here. We've got Gerald Morin. We're speaking to him in Prince Albert right now. He's a retired judge. We've also got Andrea Phillips from Legal Aid Saskatchewan. And we have Krysia Przepiorka, who works at the Indigenous Court in Calgary. She's a defense lawyer there. We also have callers on the line at 1-800-716-2221. If you've been holding for a while, you'd like to drop us a line, our email is bluesky@cbc.ca. And I'd like to go to Stuart, who's calling in from Saskatoon today. Stuart, just listening to what you have on the show and just given your experience, what do you think we need to change about Saskatchewan's court system?
Thanks so much for taking the call. It's great to hear Mr. Morin. In my experience, I worked as a community therapist in a number of First Nations, and there were three types of experiences that I'd sometimes come across. I worked in schools, and if youth probations had referred someone, I recall one individual, it was a small property crime, destruction of property. And as we talked, I realized that he was illiterate. His functional learning skills hadn't been developed for whatever reason, not being diagnosed or not being supported in his learning. So, the behavior was a frustration, but he had a guilty plea for that charge. And at grade 9, his frustration isn't going to easily change without some intensive learning and support on the educational level.
So
with adult probations, there were, sorry, go ahead.
I was going to say, so reading supports, just basic literacy, you sort of pile that onto the outside court pile of let's not keep people poor for ages and let's make sure they have basic life skills like being able to read, maybe being able to create a financial plan. And at the court level itself, you mentioned that you've also dealt with sort of the adult side of probation?
Yes. So there were a number of times individuals said they weren't guilty, but they were understanding either that they should plead guilty or just the process of perhaps having numerous trial dates that are postponed, and it's frustrating, and they think, oh, well, I'll just get it over with. And so they plead guilty, not realizing that it will pile up and cause problems for getting a job or other things. But it's a process that's really onerous for somebody, and sometimes they'd have to travel an hour or two to get to court. And, if they didn't have a ride, they might not show up, and then they have to deal with the impact of missing a court date. So those kinds of situational challenges would make, either it's convenient to plead guilty in the short term, but with long-standing issues for employment and, accumulation of numerous petty charges.
All right. Stuart, thank you for your call.
Very important discussion.
Yeah, that is.
Thank you.
I've certainly run into that situation where people are saying they want to plead guilty. It's a process that I think I did quite often in dealing with it in Cree and asking very specific questions as outlined in the criminal code to make sure that plea comprehension was properly done. A lot of times I would reject a guilty plea because you don't do it for the mere purpose of getting over things. It will take a while, but I'd often say to young people, tell me 10 years from now as to whether or not a criminal record might impact you. Let me tell you that it will. So I'm not going to accept. So these are things that certainly we worked on. You will find still people going through the cracks with respect to that. But plea comprehension process has been in place. But when I was able to do it in Cree, it even made more of a discussion with that person.
And Krysia, we can see you nodding there. Go ahead.
Sorry. Yeah, it is something that does exist. And in Calgary, I sit on a board. We've just received funding to start a not-for-profit, the Indigenous Justice Center, where we're hoping to really catch these individuals that still sort of fall through the cracks and just deal with their matters expeditiously to get it over with and get on with their lives, not fully understanding the consequences of what all of that means. And, I always tell my clients when I prepare them to come into Indigenous court, like, this is a long journey. There's going to be ups and downs. The road to recovery is a long and bumpy road, and we expect that, but it's best efforts in this courtroom. And at the end of the day, there's always the risk that you're going to jail. That risk always exists when you're in a criminal situation, a criminal charge situation. But that should not stop you from trying to achieve what it is that this court has set out to work with our participants, and that's healing. And so, I have to, when I sit with my clients, explain to them that a quick and easy guilty plea is not always in your best interest. If you're homeless, we have networks within the city. My office reaches out and individuals can go to certain agencies like CUPS or the Friendship Center, and use phones to contact our office or to contact Elizabeth Fry that gets in touch with us. So we're sort of trying to create this grassroots connection for our participants so that we can minimize these quick and dirty guilty pleas to just speed up the process and get it over for the clients, because we've noticed that goes on a lot.
Well, and this is something I think so many of our listeners in Saskatchewan, whether you've had any experience with the courts or not, that you can kind of relate to. Earlier in this discussion, we were talking about GladU Reports. It also made me think of sentencing circles. We used them for a few years. I don't see them happening that often at courts anymore. We do have a caller on the line from La Ronge. Susan, I understand that you are a former probation officer and you've tuned in. What are your thoughts on what we could change, especially with GladU Reports?
Thank you for taking the call. Can you hear me okay?
Oh, yeah.
All right. Well, I just want to say that I agree with Gerald and Andrea and Krysia. It's a good discussion. I agree with what they're saying. It's a quick question about how to get things done in a better way. I never could understand why there had to be a separate GladU worker. Why are not our people that are doing pre-sentence reports, probation, or youth workers, why can't they be trained to include that in the report? I used to do reports back in the 70s and 80s, and that's what we included, was the background in the residential school and the trauma. And it just takes so much longer and more money when it's a separate GladU report, and our people go for such a long time trying to get their matters dealt with before they can get into a healing program. So that's my question is, why can't we just have all probation officers trained in doing the report?
Well, I think there's merit to that point in relation to it, because certainly the number of trained people. I used to write reports back in the 70s. I mean, those are things that I did and learned about a bit of the process, but things were also different in terms of probation officers back then, too. But the issue of GladU Reports is fairly major. I think that it's very much specialized, and I think I know there's a judge in our court that knows a lot about GladU Reports because she had made recommendations in relation to it. So those type of things are needed. Yes, it might be costly, but I think it's mostly getting the information together. Where do you get the information of where a person went? You know, you don't want to get too much into the verification process, but you certainly want to be able to figure out which school they were in. And then we start looking, like I said, looking into which schools and what they were known for. Then you start getting into the very specialized discussions as to what they experienced and what help they got, if any, or none, and were they involved in foster home situations. But having said that, I think with the short time we have left, what are we going to do in the future in relation to, because I think as one elder said in one of the meetings, we have to quit walking backwards into the future. We have to turn around and embrace it and take a look at it, what we need to do to make our own communities safer. I think that lesson has been given to us in spades in relation to what's happening in a couple of communities. The chief and councils are always asking for help. They need help. They declare things as being major. So the help comes also in the intervention of what comes into their communities, of what they now have to deal with. Is it more enforcement they need or qualitative enforcement? In other words, in dealing with an education process. I think as Sinclair said, education got us into this problem. Education will also get us out. There are still people who don't believe or will say, oh, you're just, you're crying the blues and you're not doing anything about it. Well, they still don't understand what the impact is. So that part of the education has to be taken care of. But what do we do in the communities? And how do we have meaningful participation to make some changes as to how we relate to our own women, our people, in terms of the amount of pain and those type of interventions that need to take place in relation to domestic violence, in relation to the drugs that are coming in. Those are the type of help leaders right now are calling for. Not strong enforcement, but meaningful participation as to how they really deal with it.
This brings up an email we just got, Gerald. This came to bluesky@cbc.ca from Taryn, who writes, Indigenous court sounds like it would be very beneficial for Saskatchewan. I'm First Nations. We're getting tired of having non-First Nation people coming into our communities or representing us. What's happening in Calgary sounds like a very empowering system. It gives the client a voice, but also makes them responsible to our own people. When you're sitting in Indigenous court, those are your own people you are facing. And I'm going to actually pass this on to Krysia. We are running out of time here. So just in closing, in Saskatchewan, based on some of your experience, even working with courts in Regina, what would you say is the next step for Saskatchewan to take? Because we've heard that we need the supports, we need money, and we need to somehow break the cycle of people coming in and out of court and taking the easy plead out just because it makes the problem go away quicker, leading to longer lasting problems. What are your thoughts as we close off this episode of Blue Sky, Krysia?
I think you need like-minded individuals coming together with the same goal, and that is to reduce the over-incarceration and underrepresentation of our Indigenous people in the justice system itself. And, I will say in Calgary, Indigenous Court, when it was set up using resources that already existed. There was no special funding, as I understand, put in place. And I confirmed this with one of the judges. They utilized the relationships and what was already set up to establish this court. And so you just need like-minded individuals to come together for this goal.
All right. And Andrea Phillips has been sitting in on our discussion. She's Indigenous Policy Counsel with Legal Aid Saskatchewan. Just in closing, what are your thoughts for the future, Andrea?
I think I agree exactly with what Krysia has just suggested. Like-minded individuals need to come together to work toward reducing the number of Indigenous people that, as you indicated, are just sort of moving in and out of our justice system. And we do have the ability to use GladU in our province. We're not utilizing it. We don't have enough trained workers. With respect to GladU content in a pre-sentence report, there is some conflict there because the point of a pre-sentence report is to determine the risk of the person before the court. So if we're including GladU content, which is supposed to uplift and provide a healing plan for the person before the court, it can become contradictory. Now, I do acknowledge that there are some really great pre-sentence report writers. File Hills, Qu'Appelle Tribal Council, they do an excellent job, but they are sort of the exception in the province. Legal Aid Saskatchewan has created a GladU submission guide, which our lawyers and some Aboriginal court workers make use of to work with their clients through what would be considered a GladU submission, a smaller version of a GladU report. But, yeah.
Yeah. No, I really appreciate your time and that you've been here in this discussion, Andrea. I'd also like to say thank you to Gerald Morin, the retired judge who's now living in Prince Albert. Thank you for joining us. And thank you to Krysia Przepiorka. Krysia Przepiorka is an Indigenous defense lawyer, and as you heard, she's working with the Indigenous Court in Calgary. Thank you to all of you who've been part of today's discussion. And as always, send your thoughts. If we couldn't quite get them onto the radio, we'd love to have them by email, bluesky@cbc.ca.